Mr. Justice Brennan delivered the opinion of the court. The Presidential Recordings and Materials Preservation Act directs the Administrator of General Services, an official of the executive branch, to take custody of the presidential papers and tape recordings of appellant, former President Richard M. Nixon, and promulgate regulations that, 1. Provide for the orderly processing and screening by executive branch archivists of such materials for the purpose of returning to appellant those that are personal and private in nature, and, 2. Determine the terms and conditions upon which public access may eventually be had to those materials that are retained. The question for decision is whether Title I is unconstitutional on its face as a violation of 1. The separation of powers, 2. Presidential privilege doctrines, 3. Appellant's privacy interests, 4. Appellant's First Amendment associational rights, or 5. The Bill of Attainder clause. The background. The materials at issue consist of some 42 million pages of documents and some 880 tape recordings of conversations. Upon his resignation, appellant directed government archivists to pack and ship the materials to him in California. This shipment was delayed when the Watergate special prosecutor advised President Ford of his continuing need for the materials. At the same time, President Ford requested that the Attorney General give his opinion respecting ownership of the materials. The Attorney General advised that the historical practice of former presidents and the absence of any governing statute to the contrary supported ownership in the appellant, with a possible limited exception. The Attorney General's opinion emphasized, however, historically, there has been consistent acknowledgement that presidential materials are peculiarly affected by a public interest which may justify subjecting the absolute ownership rights of the ex-president to certain limitations directly related to the character of the documents as records of government activity. On 8 September 1974, after issuance of the Attorney General's opinion, the Administrator of General Services, Arthur F. Sampson, announced that he had signed a depository agreement with appellant. The agreement recited that appellant retained all legal and equitable title to the materials, including all literary property rights, and that the materials accordingly were to be deposited temporarily near appellant's California home in an existing facility belonging to the United States. The agreement stated further that appellant's purpose was to donate the materials to the United States with appropriate restrictions. It was provided that all of the materials shall be placed within secure storage areas to which access can be gained only by use of two keys, one in appellant's possession and the other in the possession of the archivist of the United States or members of his staff. With exceptions not material here, appellant agreed not to withdraw from deposit any originals of the materials for a period of 3 years, but reserved the right to make reproductions and to authorize other persons to have access on conditions prescribed by him. After 3 years, appellant might exercise the right to withdraw from deposit without formality any or all of the materials, and to retain them, for any purpose determined by him. The Nixon-Sampson agreement treated the tape recordings separately. They were donated to the United States effective September 1, 1979, and meanwhile shall remain on deposit. It was provided, however, that, subsequent to the 1st of September, 1979, the administrator shall destroy such tapes as, Mr. Nixon, may direct, and in any event the tapes shall be destroyed at the time of, his, death or on the 1st of September, 1984, whichever event shall first occur. Otherwise the tapes were not to be withdrawn, and reproduction would be made only by mutual agreement. Access until the 1st of September, 1979, was expressly reserved to appellant, except as he might authorize access by others on terms prescribed by him. Public announcement of the agreement was followed by the introduction of S. 4016 by 13 senators in the United States Senate. The bill was designed to abrogate the Nixon-Sampson agreement, passed the Senate on 4 October, 1974. It was awaiting action in the House of Representatives when on 17 October, 1974, appellant filed suit in the District Court seeking specific enforcement of the Nixon-Sampson agreement. That action was consolidated with other suits seeking access to presidential materials pursuant to the Freedom of Information Act and also seeking injunctive relief against enforcement of the agreement. The final version of S4016 was signed on the 19th of December. To the Act. Section 101A of Title I directs that the Administrator of General Services shall receive, obtain, or retain complete possession and control of all original tape recordings of conversations which were recorded and which 1. Involve former President Richard M. Nixon or other individuals who, at the time of the conversation, were employed by the federal government. 2. Were recorded in the White House or in the office of the President in the Executive Office buildings located in Washington, District of Columbia, Camp David, Maryland, Key Biscayne, Florida, or San Clemente, California, and 3. Were recorded during the period beginning the 20th of January 1969 and ending August 9, 1974. Section 101B provides that the administrator also shall receive, retain, or make reasonable efforts to obtain complete possession and control of all papers, documents, memorandums, transcripts, and other objects and materials which constitute the presidential historical materials of Richard M. Nixon, covering the period beginning the 20th of January 1969 and ending August 9, 1974. Section 102A prohibits destruction of the tapes or materials except as may be provided by law, and 102B makes them available in response to court subpoena or other legal process, or for use in judicial proceedings. Section 102C affords appellant access to the recordings and materials for any purpose consistent with the Act subsequent and subject to the regulations issued by the administrator. Section 102D provides for access by any agency or department in the executive branch for lawful government use. Section 103 requires custody of the tape recordings and materials to be maintained in Washington except as may otherwise be necessary to carry out the Act. Section 104 directs the administrator to promulgate regulations governing public access to the tape recordings and materials. Section 104A requires submission of proposed regulations to each House of Congress, the regulations to take effect at the end of 90 legislative days unless either the House or the Senate adopts a resolution disapproving them. The regulations must take into account 7 factors specified in S104A, namely 1. The need to provide the public with the full truth, at the earliest reasonable date, of the abuses of governmental power popularly identified under the generic term Watergate. 2. The need to make such recordings and materials available for use in judicial proceedings. 3. The need to prevent general access, except in accordance with appropriate procedures established for use in judicial proceedings to information relating to the nation's security. 4. The need to protect every individual's right to a fair and impartial trial. 5. The need to protect any party's opportunity to assert any legally or constitutionally based right or privilege which would prevent or otherwise limit access to such recordings and materials. 6. The need to provide public access to those materials which have general historical significance, and which are not likely to be related to the need described in paragraph 1, and 7. The need to give to Richard M. Nixon, or his heirs, for his sole custody and use, tape recordings and other materials which are not likely to be related to the need described in paragraph 1, and are not otherwise of general historical significance. 3. The scope of the inquiry. Regulations implementing 102 and 103, which regulate access and screening by government archivists, have been promulgated. Public access regulations that must be submitted to Congress under 104A have not, however, become effective. The initial set proposed by the administrator was disapproved pursuant to 104B(1) by Senate resolution. The Senate also disapproved 7 provisions of a proposed second set, although that set had been withdrawn. The House disapproved 6 provisions of a third set. The administrator is of the view that regulations cannot become effective except as a package and consequently is preparing a fourth set for submission to Congress. The District Court therefore concluded, and the Supreme Court agreed, that as no regulations under 104 had yet taken effect, and as such regulations once effective were explicitly made subject to judicial review under 105, the court could consider only the injury to appellant's constitutionally protected interests allegedly worked by the taking of his presidential materials into custody for screening by government archivists. No one can foresee the varying applications of these separate provisions which conceivably might be made. A law which is constitutional as applied in one manner may still contravene the Constitution as applied in another. Since all contingencies of attempted enforcement cannot be envisioned in advance of those applications, courts have in the main found it wiser to delay passing upon the constitutionality of all the separate phases of a comprehensive statute until faced with cases involving particular provisions as specifically applied to persons who claim to be injured. Passing upon the possible significance of the manifold provisions of a broad statute in advance of efforts to apply the separate provisions is analogous to rendering an advisory opinion upon a statute or a declaratory judgment upon a hypothetical case. 4 claims concerning the autonomy of the executive branch. The act was the product of joint action by the Congress and President Ford, who signed the bill into law. It is therefore urged by intervener appellees that the case does not truly present a controversy concerning the separation of powers, or a controversy concerning the presidential privilege of confidentiality, because, it is argued, such claims may be asserted only by incumbents who are presently responsible to the American people for their action. We reject the argument that only an incumbent president may assert such claims and hold that appellant, as a former president, may also be heard to assert them. We further hold, however, that neither his separation of powers claim nor his claim of breach of constitutional privilege has merit. Appellant argues broadly that the act encroaches upon the presidential prerogative to control internal operations of the presidential office and therefore offends the autonomy of the executive branch. The argument is divided into separate but interrelated parts. First, appellant contends that Congress is without power to delegate to a subordinate officer of the executive branch the decision whether to disclose presidential materials and to prescribe the terms that govern any disclosure. To do so, appellant contends, constitutes, without more, an impermissible interference by the legislative branch into matters inherently the business solely of the executive branch. Second, appellant contends, somewhat more narrowly, that by authorizing the administrator to take custody of all presidential materials in a broad, undifferentiated manner, and authorizing future publication except where a privilege is affirmatively established, the act offends the presumptive confidentiality of presidential communications recognized in United States v. Nixon, 1974. He argues that the District Court erred in 2 respects in rejecting this contention. Initially, he contends that the District Court erred in distinguishing incumbent from former presidents in evaluating appellant's claim of confidentiality. Appellant asserts that, unlike the very specific privilege protecting against disclosure of state secrets and sensitive information concerning military or diplomatic matters, which appellant concedes may be asserted only by an incumbent president, a more generalized presidential privilege survives the termination of the president-advisor relationship much as the attorney-client privilege survives the relationship that creates it. Appellant further argues that the District Court erred in applying a balancing test to his claim of presidential privilege and in concluding that, notwithstanding the fact that some of the materials might legitimately be included within a claim of presidential confidentiality, substantial public interests outweighed and justified the limited inroads on presidential confidentiality necessitated by the Act's provision for government custody and screening of the materials. Finally, appellant contends that the Act's authorization of the process of screening the materials itself violates the privilege and will chill the future exercise of constitutionally protected executive functions, thereby impairing the ability of future presidents to obtain the candid advice necessary to the conduct of their constitutionally imposed duties. A separation of powers. We reject at the outset appellant's argument that the Act's regulation of the disposition of presidential materials within the executive branch constitutes, without more, a violation of the principle of separation of powers. Neither President Ford nor President Carter supports this claim. The executive branch became a party to the Act's regulation when President Ford signed the Act into law, and the administration of President Carter, acting through the Solicitor General, vigorously supports affirmance of the District Court's judgment sustaining its constitutionality. Moreover, the control over the materials remains in the executive branch. The Administrator of General Services, who must promulgate and administer the regulations that are the keystone of the statutory scheme, is himself an official of the executive branch, appointed by the President. The career archivists appointed to do the initial screening for the purpose of selecting out and returning to appellant his private and personal papers similarly are executive branch employees. Appellant's argument is in any event based on an interpretation of the separation of powers doctrine inconsistent with the origins of that doctrine, recent decisions of the court, and the contemporary realities of our political system. True, it has been said that each of the three general departments of government must remain entirely free from the control or coercive influence, direct or indirect, of either of the others. And that, sound application of a principle that makes one master in his own house precludes him from imposing his control in the house of another who is master there. But the more pragmatic, flexible approach of Madison in the Federalist's Papers and later of Mr. Justice Story was expressly affirmed by this court only 3 years ago in United States v. Nixon, supra. There the same broad argument concerning the separation of powers was made by appellant in the context of opposition to a subpoena duces tecum of the Watergate special prosecutor for certain presidential tapes and documents of value to a pending criminal investigation. Although acknowledging that each branch of the government has the duty initially to interpret the Constitution for itself, and that its interpretation of its powers is due great respect from the other branches, the court squarely rejected the argument that the Constitution contemplates a complete division of authority between the three branches. Rather, the unanimous court essentially embraced Mr. Justice Jackson's view, expressed in his concurrence in Youngstown Sheet and Tube Company v. Sawyer. In designing the structure of our government and dividing and allocating the sovereign power among three co-equal branches, the framers of the Constitution sought to provide a comprehensive system, but the separate powers were not intended to operate with absolute independence. Like the District Court, we therefore find that appellant's argument rests upon an archaic view of the separation of powers as requiring three airtight departments of government rather, in determining whether the Act disrupts the proper balance between the coordinate branches. The proper inquiry focuses on the extent to which it prevents the executive branch from accomplishing its constitutionally assigned functions. Only where the potential for disruption is present must we then determine whether that impact is justified by an overriding need to promote objectives within the constitutional authority of Congress. It is therefore highly relevant that the Act provides for custody of the materials in officials of the executive branch and that employees of that branch have access to the materials only for lawful government use, subject to the administrator's regulations. For it is clearly less intrusive to place custody and screening of the materials within the executive branch itself than to have Congress or some outside agency perform the screening function. While the materials may also be made available for use in judicial proceedings, this provision is expressly qualified by any rights, defense, or privileges that any person may invoke, including, of course, a valid claim of executive privilege. Similarly, although some of the materials may eventually be made available for public access, the Act expressly recognizes the need both to protect any party's opportunity to assert any legally or constitutionally based right or privilege and to return purely private materials to appellant. These provisions plainly guard against disclosures barred by any defenses or privileges available to appellant or the executive branch. The executive branch remains in full control of the presidential materials, and the Act facial is designed to ensure that the materials can be released only when release is not barred by some applicable privilege inherent in that branch. Thus, whatever are the future possibilities for constitutional conflict in the promulgation of regulations respecting public access to particular documents, nothing contained in the Act renders it unduly disruptive of the executive branch and, therefore, unconstitutional on its face. And, of course, there is abundant statutory precedent for the regulation and mandatory disclosure of documents in the possession of the executive branch. See, e.g., the Freedom of Information Act, the Privacy Act of 1974, the Government in the Sunshine Act, the Federal Records Act, and a variety of other statutes. Such regulation of material generated in the executive branch has never been considered invalid as an invasion of its autonomy. Similar congressional power to regulate executive branch documents exists in this instance, a power that is augmented by the important interests that the Act seeks to attain. FN 8. FN 8. We see no reason to engage in the debate whether appellant has legal title to the materials. Such an inquiry is irrelevant for present purposes because 105 c. assures appellant of just compensation if his economic interests are invaded, and, even if legal title is his, the materials are not thereby immune from regulation. It has been accepted at least since Mr. Justice Story's opinion in Folsom v. Marsh, that regardless of where legal title lies, from the nature of the public service, or the character of documents, embracing historical, military, or diplomatic information, it may be the right, and even the duty, of the government, to give them publicity, even against the will of the writers. Appellant's suggestion that the Folsom principle does not go beyond materials concerning national security and current government business is negated by Mr. Justice Story's emphasis that it also extended to materials embracing historical information. Significantly, no such limitation was suggested in the Attorney General's opinion to President Ford. Although indicating a view that the materials belonged to appellant, the opinion acknowledged that presidential materials without qualification are peculiarly affected by a public interest which may justify subjecting the absolute ownership rights to certain limitations directly related to the character of the documents as records of government activity.